can start now,
sir.
Yeah, 1 second. You have checked the YouTube and everything is fine. It is running.
Yeah.
People are already there in the YouTube. That you can start now. 1 second. 1 second. 1 second. Let me 1 second. You have checked the YouTube and everything is fine. It is running. Yeah. Yeah. YouTube is running. You are already there in the YouTube. That you can start now. 1 second. 1 second. 1 second. Yes, sir. Everything is perfect. All right. Why don't we start, sir?
Yes.
Server room has to confirm to Santosh madam.
Hello.
This meeting is being recorded.
Yes,
Yeah.
Santosh madam, you can start.
Yeah. Thank you, Vinod. Hi, good evening, everyone. I'm CA and IP Santosh Goyal. Persistent Insolvency Professionals Private Limited, a company owned by us insolvency professionals. With pan-India domain experts and consultants, it provides support services to its members. PIPPL has been imparting knowledge to its members through these knowledge sharing seminars. And these seminars ensure that the members are abreast in the field of insolvency. They are updated in all aspects of insolvency. So in continuation to these webinars, today's special session on individual insolvency will enrich us all. Nowadays, there are a lot many assignments on personal guarantors, and many PIPPL members are also handling such assignments. So with these words, I request Mr. G.S. Narasimha Prasad ji, who is a promoter and the director of PIPPL, to welcome all the members. Over to you, sir. Narasimha sir, over to you.
I was cross-checking whether.
Sir, please unmute, Narasimha ji.
नरसिम्हा को allow करोगे तब ना उसको.
Yeah, can you hear me?
Yes, sir.
I could just unmute. I was allowed, and my video is still there is some problem with it. Sethi Saab, see if you can do something, because it says host
Let me check.
has to allow it.
Host has disabled it.
Yes, exactly. Nevertheless, let's start off. Let me not hold the proceedings.
You can start video, I think.
No, sir, I cannot. It doesn't allow me.
Yes, sir.
Now it did. Now it did. Now it did. It was waiting for Mr. Sethi to say yes. I think by word also, not just over the system. Yeah. Very good evening to all. Thank you, Santosh ji.
Thank you.
It's very nice to be back on our knowledge sharing series. I'm Narasimha Prasad. Very good and warm good evening to all the participants here. And we very happily and gratefully acknowledge the presence of many of IPs who are not our members as well, who are invitees, who showed interest, who took the trouble of accepting our invitation and joining and registering themselves and joining in this webinar. This is another session in our continuing knowledge sharing series. The purpose being that, all of us as IPs, we have a dire need and a requirement, professional requirement, to be up to date, to be cognizant of all the developments that are happening, because as it has been said many an occasion by many an expert in our field, the IP or the RP of an assignment is supposed to be knowing everything, doing everything with all the liabilities and experience, I mean, the responsibilities that can come upon him or her. All the timelines, everything is to the RP. So we need to be updated. We need to be cognizant of all the developments all the time, up to the time. So this is another session in that series. Today, particularly, Mr. Vinod would be taking us through one important development, rather, I should not say development, that is, it is something like that has become the current one in the sense that the personal insolvency, that is of the guarantors of a corporate which is in CIRP. So guarantors insolvency process. So many banks, apparently, as you have all seen, have gone about using up that option significantly. So there are many inquiries coming up. So this is a very, very relevant, very useful information base that we need to be updated about. Let me not take too much more time in this. And so a very warm welcome to all of you, of course, to all our members, our directors. Over to Santoshji. Thank you.
Thank you, sir, for such a hearty welcome. And it's very true, yes, that members need to be updated. Unless and until we continue with all this, our continuing education programs will just be left behind. Thank you, sir. Now I request Mr. Rajendra Puranikji, who is also a promoter and a director of our company PIPPL and an insolvency professional, to throw some light on the knowledge sharing series which is being conducted by PIPPL. Over to you, sir.
Yeah, thank you, madam. Am I audible?
Yes, sir, you are.
Yeah. Good evening and warm welcome to our insolvency professionals, bankers, members of our company, Persistent Insolvency Professional Private Limited. I am Rajendra Puranik, Director of Persistent Insolvency Professional Private Limited. We are a company of 127 insolvency professionals and valuers all over India. Other directors of the company are Mr. KJ Vinod, Mrs. Ramila Rangaswamy, Mr. Anup Prakash Avasti, Mr. Narsimha Prasad, Dr. Nandakishore Singh, Mr. Paramjit Singh Sethi, Pradeep Kumar Kaushik, and Mr. Vimal Kumar. Our company was formed on 14 February 2022. We are having head office at Hyderabad and corporate office at Mumbai. Our team is made up of CAs, cost accountants, company secretaries, bankers, advocates, and valuers in all three disciplines of plant and machinery, land and building, and SFA. Across India, we have got 127 offices of all our IPs. So everybody is having offices in 127 locations, and we have got presence in all 15 NCLTs across the India. We have an advisory board who are having experiences handling monitoring 2,000 cases of large, biggest nationalized bank. Then we have got advocates of Supreme Court. We have got ex-MDs of the bank. We have got ex-chairmen of the cooperative bank on our advisory board. So it's a very, you can say, knowledgeable advisory board we are having along with our board of directors and members. Our website is www.persistentinsolvencyprofessionals.com. You can give any suggestion to any of us regarding our operations or anything you want to understand at our info@pipeople.in. So these are our basic information about our company. Now let us discuss about our today's lecture. No, actually we are having a series of webinars with our experienced persons. I think we are having one educational classes every month with our Suresh Kumar sir, who is having a lot of experience in IBC. So last week we had a roll up COC in CRP. Earlier we were having a interplay between section 30, 52 and 53. So next month also we are having series. So up to March, every month we are having educational series by Mr. Suresh Kumar sir. So actually I know we are all experienced IPs. All we have passed the exams. Everybody is aware about the Bear Act of IBC. Everybody is aware. But what is the importance of this webinar is, okay, this webinar is given by our Vinod sir, who is the promoter and founder, who has the experience of handling IBC cases, around 25 plus cases. So he will give you practical insight in handling the cases, because see, we know all theoretical knowledge, but unless you get the practical input, we will not be able to handle the cases, how to face COC, how to handle meetings, all these things. So our promoter, Mr. KJ Vinod, has handled more than 25 cases, and he is in this line almost for more than 3 years. So with these words, I will welcome all the members to keep learning, keep joining our webinars every now and then when information given to you. And our lectures can be heard at our YouTube channel. So you can have a recorded lectures at there also. Thank you, madam. Over to you.
Thank you, sir. Yes, our company has a pan-India presence, and this is due to this pan-India basis from which we are getting support all over India. Now I request Mrs. Ramila Rangaswamy. She's also director in PIPPL, a company secretary and insolvency professional by profession, to enlighten us all on the assignments of individual insolvency. Over to you, madam.
Thank you, ma'am. Good evening to each and every participants for today's webinar. Just I want to say a few words on insolvency of individual. The Insolvency and Bankruptcy Code envisages insolvency resolution of three categories of individuals: personal guarantors to corporate debtor, partnership firm, proprietorship firm, and other individuals. Each category is unique and needs a separate dispensation for resolution of its insolvency. A category may have several subcategories, each of which may require customized process. Further, the stakeholders need guidance on how to use the insolvency process to their advantage. Government, considering our Indian business scenario in mind, thought it fit to have an appropriate phasing and sequencing of implementation of individual insolvency is very essential in synchronizing with the legislation intention. In first phase, the provisions of the code relating to insolvency and bankruptcy personal guarantors to corporate debtor got implemented. This is in synchronous with the CRP of corporate debtor. The provision relating to partnership firm and sole proprietary concern may be implemented in second phase. In the third phase, the provisions of the code dealing with insolvency with other individuals will be get implemented. Government has come out with three-phased implementation in order to make the stakeholders to enable learning from earlier phases one by one and to have better understanding as well as for their efficient implementation. Now, almost all financial creditors have taken steps to move their steps to file application for insolvency and bankruptcy of personal guarantors to corporate debtor. So it is the right time our PIPPL thought it fit to make our IP families to understand and get trained and to enrich their knowledge to take up the assignment. Then a few members of our PIPPL already are handling and about to get assignments on insolvency of personal guarantors. Our PPPL is having adequate infrastructures and talented persons to guide our family members in all respect. In the nutshell, what I want to say and conclude is many personal guarantee cases are coming up. So please all enrich our knowledge through this webinar to tackle the personal guarantee cases successfully. Thank you, ma'am.
Thank you, madam. And very well said. I'm too having a PG case. And these seminars are really, really very helpful to me. Thank you, PIPPL team. Now we have with us Mr. Anu Prakash Avasthi, who is also director in PIPPL. He is an advocate on record of Supreme Court and insolvency professional. He is a legal counsel to IPs in NCLT, NCLAT, and Supreme Court. I request Anu Prakash to clarify the legal position of personal insolvency under IBC code. Over to you, sir.
Thank you so much, Santosh Goel, ma'am. And I think there is some difficulty, technical difficulty. I think whether I'm visible or not visible.
Yes, sir. Yeah, you are visible.
Yes. But the screen actually shows that some KJ Saab has started screen sharing and it's a big blank. I'm not able to actually remove that big blank from my screen. So anyway, so if I'm visible, so okay, fine. So thank you very much and very good evening to all the participants. I am Anup Prakash Awasthi, advocate and recorded Supreme Court and insolvency professional and director of the PIPPL. And friends, as you are aware that this personal guarantee or the PG, it was not initially actually notified by the process. So it has come into force by way of SO dated 15th of November 2019, and by that section 94 to 187 were enforced, and that's how we are having PG as on date. And it was challenged immediately before Honorable Supreme Court of India, and not by one person, but bunch of petitions were filed in various high courts, even before Supreme Court directly by way of a writ petition. And ultimately, the lead petition was Lalit Kumar Jain versus Union of India, in which on 21st of May 2021, ultimately these sections which enabled for the personal insolvency were held not to be ultra vires of the code, and they were held to be in order. So actually what I want to tell that this particular notification was challenged on 2 counts before the Honorable Supreme Court of India. On first count, they were saying that the section 1 subsection 3, by which the code has to be come into force in various phases, is making it a conditional legislation. So, and since the promulgation of these sections are, this notification are putting into force, these notification was only with regard to one portion. So this is a kind of selective legislation, and that is ultra vires of the powers of central government to do so. As such, it should not be, should not have been notified, and if notified, it should be declared nullified. That was the first challenge to this. And next was the common actually understanding that once the main borrower's liability goes in terms of resolution plan, nothing should remain with regard to the personal guarantors. So that was the other contention, that the borrower's liability, the guarantor's liability is co-extensive vis-a-vis the principal debtor in terms of section 128 of the Contract Act. And upon conclusion of the insolvency proceeding, once the resolution plan is approved, our company goes into liquidation, it is sold, and the entire process is complete, winded up. So nothing remains, nothing should remain for the personal guarantor, and no recovery should take place from the personal guarantor. So they did not challenge 94, where the person or the firm was actually permitted to move for that. But they said that the entire notification is ultra vires because the entire liability goes. So that is what has been actually discussed in that particular judgment, and ultimately court concluded that that cannot be. And reasons are very clear, that see, if this is a this entire business of giving loan, giving guarantee, has a tripartite triangle. There is a triangle, financial triangle. On one side, you will see that there is a financial creditor. On the other side, you will see that there is surety. On the third side, you see there is a principal debtor. And if that principal debtor is a company, that is corporate debtor. So the personal guarantor to the corporate debtor has a right that competes with the right of the lender, the creditor. And the creditor's right precedes the right of the surety. So they can at the maximum entitled for indemnification from the main borrower, principal borrower, not otherwise. So if the principal borrower fails to pay any amount to the financial creditor, then it is ultimately the liability of the surety to pay the same, because he has given the guarantee for that loan. And the lender is also having a choice whether to go first against the principal debtor or to go against the surety. That choice is always available, because the law does not discriminate against a surety or the principal borrower. They are equally liable to repay the debt to the main lender. So as and when actually the principal debtor goes into insolvency, that means they are insolvent. They are not in a position to fulfill their obligation to the financial creditor. So there is no repayment, there is no recovery taking place under the IBC. A resolution takes place. So the principal debtor being insolvent is not able to actually honor the obligations. So that means no recovery is taking place. So the liability of the surety subsists. They have personally guaranteed that in case they fail to repay, I shall be paying. So irrespective of the fact that a resolution is happening and substantial amount is being recovered by the financial creditor, if something remains, then they come after the personal guarantors. Had that been a case of OTS, where quote unquote recovery was taking place, lesser recovery was taking place, so that was rescinding the main agreement between the principal borrower and the creditor. So that is not happening in this case. That's why the liability of the surety remains, and the guarantee can be being a separate contract altogether from the main borrowing contract, can be put into action, and recovery can take place from the personal guarantors. And if both of them go insolvent, then there is another important issue. If the principal debtor becomes insolvent, simultaneously the personal guarantor also files for its insolvency. So, and the IBC says it should go before the very bench where the case of the principal debtor, the corporate insolvency of the principal debtor is taking place. Reason is there is one default that is proved against the corporate debtor, and the personal guarantor's case is also part of that. So there shall not be a need for reproving the same. It shall go in the same process, and if protection is available, some kind of protection is available against coercive action to the principal borrower, the corporate debtor, similar kind of things shall be available to the personal guarantor. So it is a kind of doing ease of doing. So had there been a OTS, there was a clear case of extinction of the liabilities of the personal guarantor at the same time, because no debt subsists. But where there is a resolution, it is completely different from settlement, different from recovery. That's why the bankers are having subsisting cause of action against the personal guarantor, and the insolvency of personal guarantor can also be taken recourse to. So that was the crux of that entire judgment, if I say in nutshell, where it has been held that yes, government is having that power, that they can make even conditional legislation. They, since there is no new legislation, only the portion is getting into effect on X, Y, or Z date. So the code has come into action, and it was an experimentation. After the system got matured, got in tune, slowly, gradually in 2019, they realized that next phase should be disclosed before the stakeholders. And that's how this personal guarantee and other related 94 to 187 was pressed into action. So on that annual, Supreme Court actually visualized everything and concluded that the sections are not ultra vires. This is not contrary to the mandate of the law, and it is also within the competence of the central government to notify the same. And that's how it has come in power, and its legal sanctity or validity was upheld. Now there, and it was argued by Harish Salve and Abhishek Manu Singhvi also participated in that. All big legal luminaries have given their arguments against the coming into effect of these sections, but it has come into force, and till date there is no stay. But there is another set of petition that is pending before Supreme Court, and that is little bit worrying me, because there are actually 5 or 6 sets of petition that has been filed now. Once the coming into effect, that notification which has put these sections into effect have been held to be valid, justified, and within the legal competence of the promulgating authority. Now these sections have been challenged on the annual, especially Section 95 subclass 1, Section 96 subclass 2, Section 97 subclass 5, Section 99 subclass 1, subclass 2, subclass 4, subclass 5, subclass 6, Section 100 as ultra vires of Section 14 and Section 19(1)(g) of the Constitution. And incidentally, I have not come across anybody who actually opposed this except State Bank of India in one writ petition 510 of 2022, where they requested that there should not be any order for the RP not to file a report in the matter. So as on date, there are 5 or 6 sets of petitions and pending before different courts in Supreme Court in 5-6 benches. And the bench of Justice Dinesh Maheshwari and Belayam Trivedi, they have actually passed certain orders, and which has given a kind of status quo on those petitions that the personal guarantor shall not actually alienate any of their assets, and the RP shall not file its report. So both way, it is a kind of stand still before the Supreme Court. So that is a worrying thing that I see as on date, because this is going on even in October 2022. I have seen the orders. So, but there is another aspect of the same, that unless and until you approach the Honorable Supreme Court, the other side against whom this personal insolvency is triggered by the banks and other financial institutions, since these are interim order, these orders are effective only to the case, specific case, not to entire personal insolvency regime. So that way, each one has to travel to the Supreme Court. The trend that I see, that in each and every case, identical orders are being passed. So unless this particular issue, whether these sections 95, 96, 97, 99, and 100 are not ultra vires of the Article 14 and 19(1)(g), there will be some difficulty. But as per my experience, as per the normal trend in Supreme Court, I think that these challenge may not succeed, because this is basically trying to say that we shall not pay in a nutshell. So, but it will definitely take time. I wish court takes any view otherwise, then the future will not be that much bright. But as on date, there is no stay, except these specific cases in which certain interim orders are passed. So I think I have tried to give some feedback on the current legal position on this PG issue. And I request Mr. Vinod to take it further the way he wants. Santosh Govalman, over to you for continuation of the session.
Yeah, thank you, sir. Really, it was very helpful, very valuable deliberation. And now is the time we all are waiting for the special session on individual insolvency by our founder member, Mr. KJ Vinodji. Mr. KJ Vinodji, he has more than 28 years of experience in corporate financing, debt restructuring, angel investment services, startup funding, and is currently handling more than 25 assignments in CIRP assignments as RP and liquidator. He is a motivating factor for all the members. And now I request Mr. Vinod, sir, to lead the floor and enlighten us all with his deliberation. Over to you, sir.
Thank you, Santosh Madam. Great to see that a good gathering. And just wanted to few correction. Everybody talking about 25 cases, my experience. I just want to make it sure that people should not mistake it. I am having in my name some 6-7 assignments. And 4-5 assignment I have given consent and it is waiting. What is this 25 number? I just want to clarify that. For the last year, I am in the insolvency field working with Malingam Suresh Kumar. In the first year, I was an employee with him. After resigning from the corporate, he only brought me into the field of insolvency, and I am a ground officer for him. I mean, most cases we are coming to the going concerns, we've got a lot of intricacy to manage it. So I am at ground level as well as back office level. That is what people are referring to me, experienced like that. It is true, but it is not in my name, and my name only 5-6 cases, that it is open data available for all of you. In our platform, we are having 2 members of PIPPL is already continued with the insolvency of personal guarantor. They are going through. Yeah, for me, already given 2 consents and other 3-4 EOI is pending. So what is our attempt? We are attempt to make a comprehensive study so that we will be able to take our assignments better.
Vinod sir, I request to be a little louder. There's some problem. Audio is not very clear.
Now it is audible?
Yeah, it's better now.
Because I just kept it little. Whatever I said, it was audible to the people, or still I have
It was. I'm receiving messages that it's a little problem. Audio quality was not good.
Oh, audio quality. Now it is okay.
Yes, yes, sir, better.
Fine. I was given a clarity that people are talking about 25 assignment in my name. Later, people will go and see the IBVA site that this gentleman is having only.
Yeah, yeah, yes, sir, yes, sir. But experience matters.
Yeah, I am associated with Mahalingam Suresh Kumar. I'm a ground officer for him as well as back office manager for him to take the assignments. That's what my biggest experience in different industries and all those things. And in our platform, PIPPL, our members are already handling assignments, and I'm also having assignments with me and already given some EOI for the assignments. Because nowadays, this personal guarantee is little hot in the market. So this attempt is a comprehensive study on the personal insolvency segment. Because being an IP, we were thought of getting into the CIRP and liquidation. Even PPIRP also, not much people are not working on that or concentrating on that. So actually, it is an outcome from our combined study. Santosh Goyal Madam is handling cases, and Roshan Lal is handling cases, and from Calcutta, our Rajana Madam is handling cases. Some other cases are there. Now, I just wanted to get started because already we have enough time with the other matters and all those stuff. So I'm just straight away going to the presentation. Just want to check with the Setiji that my presentation is proper and it is visible to all well, sir?
Yes, sir. Fine.
Fine. Fine, readable and everything is fine? Perfect.
Yes.
Okay. See, part 3. That's what talking about the personal insolvency. Section 78 is talking about the applicability of the personal insolvency. This part shall apply to matters relating to the fresh start. But fresh start is not notified, and insolvency and bankruptcy of individual and partnership firm. Partnership firm is also not notified. Insolvency and bankruptcy of individual is also not notified, but personal guarantor to the corporate is notified. So that is what nutshell on the part 3. The minimum amount of default, it is 1,000. I think that is because of the fresh start matter, this 1,000 limit is there. Anyway, it is the minimum level is 1,000 rupees default. Part 3 consists of insolvency and bankruptcy of individual partnership. Anyway, partnership is not notified, though there is nothing to do with that. Now we are going to concentrate on only on individual, that too personal guarantor, which is notified. Part 3, IBC 2016, insolvency and bankruptcy for individual and partnership, which is having chapter 1, which is preliminary, talking about the application and the definition start, etc. Fresh start, which is also not relevant for us. The relevant part is chapter 3 of insolvency resolution process, which is more or less what we seen in the CIRP. But the difference is that in CIRP, we are taking the possession of the CD. Here it is little, we have to be very conscious about that, which we'll be talking later when we are getting to the chapter. And when the insolvency resolution process is not materialized, then the next step, as usual, what we are seeing in the corporate liquidation, here it is called a bankruptcy order for individual and partnership. The partnership is not relevant. Now, if we talk about the part 3 of this insolvency resolution process, for getting an understanding to the subject, I just put the titles which are generally applicable in the within the chapter. Number one, always there should be an application to adjudicating authority. Then obviously the question of interim moratorium, it's a separate word is coming, interim moratorium. In the CARP, we have seen that moratorium, here it is interim moratorium, that we will see in detail. Interim moratorium is generally on the time, at the time of filing the application itself is getting started. Whereas
Sir, sorry for interruption, sir. Sir, many are not able to hear your voice, sir.
Is it now audible?
For me, it is okay, but many
Yes,
are.
sir. Fine.
For me, it is okay, sir.
For me also fine. It is fine.
Yeah,
It is fine
now.
Okay, sir, carry on.
Can I? Okay. So before we get into the new chapter, wanted to get a run through the whole things what is there. It is as usual in every case there is an application to adjudicating authority. Obviously, the moratorium question come here. Unlike the CARP, the moratorium word is started with the interim moratorium. That is at the time of filing application itself, it is starting. We will see that is in detail. Now, the position of appointment of resolution professional. Obviously, there is a removal also is coming that we will see. Submission of report by the resolution professional to the adjudicating authority. Once he appointed, he has to give a report to the adjudicating authority, whether the application is to be accepted or rejected. That's a wonderful thing. Here we are the people who have to give the opinion to the adjudicating authority that, my lord, is it maintainable or not maintainable? We will see that in depth. Admission and rejection of application based on the report filed by the resolution professional. Then the question is coming, after admission, it is coming the moratorium. So the word in the interim moratorium, like IRP become RP, here the moratoriums take place. Once this position is taken up, then the public notice and claim for the creditors is coming up. Then registering claim and preparation of creditors list, payment plan and reporting of repayment plan by the resolution professional to the adjudicating authority, then summoning for the meeting of the creditors. You know, earlier in CRP we see everything, we will fix it and then submit. Here it is coming on a different fashion. Then conduct of the creditors and approval of the repayment plan. Approval of repayment plan by the creditors. Then the notice of decision taken in the meeting of the creditors is submitted to the adjudicating authority. Now, based on that, adjudicating authority taking a decision on the repayment plan. Then coming the implementation, supervision, repayment plan, like what we are seeing in the CARP, no? That's what implementation plan. After that, there's a completion stage or a failure, permanent failure of the repayment plan. In case of failure, as we seen in the CARP, failure of submission of a resolution plan, it will lead to the liquidation. Here it is going to be bankruptcy. If everything is complied with the repayment plan, then the discharge order for the repayment plan is completed. These are the area in the first part of the resolution process. And in this meeting, we are going to discuss about only the resolution plan. Next week, we will be scheduling the liquidation plan. There we will take that is separately. Otherwise, it is not possible to take everything in a comprehensive manner. People, the viewers and the listeners maybe also get confused, or maybe may not get digested also, may not get even like also. So we are moving to the timelines. Why this timeline? We are talking in the initial to give an idea on what are the timeline we are having in CARP and what we are having here in this situation. So it is starting with the section 95 for C, the failure by the debtor to pay the debt or serve of the notice, a demand notice. So a demand notice is to be served. So the demand notice is to be served within a period of 14 days. The section 95 can be invoked. So as usual, we have to, as in the case of section 9, here we have to file a demand notice. Then we have to wait for a 40 days, then we can invoke section 95. Then the position coming to the IRP, this is little critical. I also penalized by IBB for this particular problem because I just explained it. Form IP1, which is belonging to the CIRP regulations. IP1 is to be filed within 3 days of signing Form 2 or Form A. This is what IP1 is talking about. But the beauty of that, when we open IP1, there it is coming, you are appointed as an IRP, RP, liquidator, personal guarantor to the corporate debtor. Now, you know, the problem is come up. I have to register with IBBI that I have taken this assignment. The obvious way, we have to file IP1. But you know, IP1 is in the CIRP regulation. Now, you see, no rule or regulation is available in Chapter 3, either in the application rules or in the resolution process rule or in the section itself. Now, the question is that that option is given in the IP1 form, whereas law is silent, regulation is silent, rule is silent, whether while we file for A, we have to file IP1. What I did, I was going through the sections ABC code. Since I concluded that since there is nowhere it is mentioned that while filing Form A, I need to file IP1. But inside the IP1, it is written there. What I did, I filled it and filed it. Got delay. We can go further only after payment of the necessary penalty. I paid it and filed it. Now I will be writing to IBBI asking that detail. So my request to the people, as far as concerned Form A, we should not delay filing IP1 because in IP1 that option is there. Tomorrow, I don't know what will be going to happen by the IBBI. For avoiding problem, better it is filed, or you wait, I will write to IBBI and get back what is my response. Now, appointment of RP, resolution professional, by adjudicating authority on an application filed with the adjudicating authority under section 94 or 95. If the application is filed through IP, then adjudicating authority within 7 days has to write to IBBI, and within 7 days, IBBI has to revert to adjudicating authority. In second option, if there is no application is filed under section 94 or 95 through an RP, then the same process, 7 days adjudicating authority need to communicate, and 10 days IBBI has to revert. See, this is only in the law, but actually what is happened, IBBI is already given empanelment list from there adjudicating authority pick up the name. But in that order, what adjudicating authority write, please submit your disqualification related matter within 10 days or few days. That's what. Santosh madam, within how many days we have to report when we are getting order from adjudicating authority about the disqualification matter? Within how many days we have to revert to the adjudicating authority that yes, my lord, I have no disqualification for IBBI?
No, we have to make an application, give our consent to NCLT.
Yes, so that is what. So everything is written here. This is not followed. That's what I mean to say. Now, Rule 9 of the application, application rule talking about 94 or 95 shall be provided to the insolvency professional on his appointment under section 95(5) of an insolvency professional by the applicant, if not provided earlier. Correct. So his name is not provided earlier, then within 3 days, the petition what is filed with the adjudicating authority is to be given to the RP when after his appointment within 3 days. By who is to who has to give? By the creditor. Okay. And when the question of replacement of either by debtor or creditor, the same process IPP has to follow as per the rule, but it is not followed. But we can ignore that portion since it is followed by empanelment list. Section 99(1). Resolution professional shall examine the application referred in section 94 or 95, as the case may be, submit a report to adjudicating authority recommending approval or rejection of the application. This should be done within 10 days of his appointment. You know, I already told there is an application filed with adjudicating authority, and when he appointed, after that, within 10 days, he has to give a report, the legitimacy of the application. Now, this is the first task of a resolution professional to be done. Now, if we are not sure that what we do in this level, then we will be in difficulty. We will call so many people will give so many directions. That's the reason we are taking it up on an open platform. What we have to do here, that we will be explaining, and what are the documents we have to verify, that also we will be explaining. This is the first task that we have to do. Now, another timeline is coming under section 99 for the purpose of examining an application. The resolution professional may seek such further information or explanation in connection with the application as may be required from a debtor or a corporate debtor or any other person. This we have to find out, any other person who in the option of the resolution professional may be provided such information. Then such person to whom the information explanation is asked shall furnish the information to the RP within 7 days of the receipt of the request. Now, here it is the other person which is very important and relevant, which I will come back. Section 100, which is the admission section of the application, adjudicating authority shall, from the date of submission of the report under, under section 99, that is what the report what we file, pass an order either admitting or rejecting application referred in section 94 and 95 in this case. They are telling that 14 days, you know that these are not mandatory, but it is these are not mandatory, but it is what you call the regular procedural rule. Now section 100 again, which is talking about the adjudicating authority shall provide a copy of the order passed under regular under section 101 along with the report of the resolution professional and the application referred in section 94, the original application 94 or 95, as the case may be, to the creditor from the date of said order. So from the order within 7 days, we have the adjudicating authority has to give a copy to the creditors from the date of this order. Now section 102, which is talking about the public advertisement and the claim from creditors. This is to be happen within 7 days of passing the order. Now you know section 102 inviting claim from creditors, it is in form B. Creditor has to file the claim in form B. There is only one form, and within 21 days of the notice, from the notice 21 days, they have to file the claim. Another thing, section 106(1), the resolution professional shall submit the repayment plan under section 105 along with his report or such plan to the adjudicating authority, right? So this is to be happen within a period of 21 days from the date of submission of the claim under section 102. 102 is the invitation of the claim. Section 106 again 3. The report referred in subsection 2. The report of the creditors shall also specify date on which and the time and the place at which the meeting should be held. If he is having the opinion that at a meeting of creditors should be summoned, you need, please mind it, in certain cases there is no requirement of calling a meeting of the creditors. But in certain cases, it is very mandatory to have the meeting because of the intricacy. Correct. So it is the option of the, cannot say option, it's the discretion of the resolution applicant to reporting to the adjudicating authority that whether meeting of the creditor is to be summoned or not to be summoned. So 106 4A says the date on which the meeting is to be held shall not be less than 14 days and not more than 28 days. So after this, within 14 days or maximum of 28 days, the meeting is to be summoned. And what is the notice period of the meeting? It is 14 days. So after giving the 14 days meeting, what is the next procedural follow-up is to be happen? Section 108(4), the resolution professional may, for the sufficient cause, if he is having the sufficient cause, he can adjourn the meeting of the creditors for a period not more than 7 days. Only at a time. At a time, he can, if he having certain reason, then he can adjourn it for 7 more days. And 7 more days means adjourning the previous meeting fixed earlier, right? Now, section 1171, a resolution professional shall, on the completion of the repayment plan, forward to the person who are bounded by the repayment plan under section 115 and adjudicating authority. File the repayment plan to the adjudicating authority. The following documents he has to file. That to happen within 14 days. Okay, from the meeting. A notice of the repayment plan has been fully implemented. Yes, my lord. As per the repayment plan, the notice, as per the implementation plan, the repayment plan, it has been implemented in full. Or B, a copy of the report by the resolution professional summarizing all the receipts and payment made in pursuance of the repayment plan and extent of the implementation of such plan as compared with the original repayment plan. Correct. So when we do the actual realization and the repayment, which may deviate from the original plan, right? Section 1172, again, the resolution professional may apply to the adjudicating authority to the extent the time mentioned in subsection 1 for further period not exceeding 7 days for submission of the data. Now we are going to come to the sections. Before that, we have to understand certain critical area of the personal insolvency. Now, section 7(1), this is the preliminary part. Talking about adjudicating authority means the debt recovery tribunal constitute under section 1 of section 3 of the Recovery Debts Dues to the Bank and Financial Institution Act 1993. This is what intro section 79 is talking about. Now, we have another section 62 of IBC, which says where a corporate insolvency resolution process or liquidation proceedings of a corporate debtor is pending before the National Company Law Tribunal. What is that? A corporate CARP or liquidation is pending of a corporate debtor in NCLT, an application related to the insolvency resolution or a liquidation or bankruptcy of a corporate guarantor or a personal guarantor, as the case may be, of such corporate debtor shall be filed before the National Company Law Tribunal. This is what making the difference. Now, rule 3 of the application to the adjudicating authority, it says that adjudicating authority means for the purpose of section 60, the National Company Law Tribunal constituted under section 408 of Companies Act. In all other cases, DRT. So it is very clear from the rule 3A that yes, for the purpose of adjudicating authority, for the purpose of section 60. Section 60 talk about what? Liquidation or bankruptcy of a corporate guarantor or CARP and liquidation of a corporate debtor. For this purpose, the adjudicating authority is NCLT. It's very clear. Okay. So adjudicating authority, now we are clear about it, or personal insolvency, that is of personal guarantor. Now, before we get into the sections and regulations, etc., we should understand certain things. Here we are having two sets of form. One form is coming from the application to the adjudicating authority of insolvency resolution process, personal guarantor. Here we are having four forms, A, B, C, D. We have to take it as A, B, C. D, form D is the withdrawal form of insolvency resolution process. As we seen in 12A, like that, there is a process for withdrawal of the application, which is to be filed by form D. So A is talking about the application by the guarantor to initiate the insolvency resolution process. And form C is talking about application by creditor to initiate the resolution process. Mean form A is used for the section 94 and form C is used for the section 95. Now what is form B? B is the demand notice, which we see in section 9 that we have to give a demand notice, we have to wait for 10 days. Here we have to give a demand notice in form B and we have to wait for 14 days. So this is what the adjudicating authority rules is talking about for forms. That is what it is there. Now, if we come to the resolution process personal guarantor regulations, there are three forms. Number one, the written consent to act as resolution professional, which I already told you that form A. When we file form A, you know whether we have to file IP1 or not. IP1 is CARP regulation, we cannot take it that, but again in the CARP4, I mean IP1 this is inbuilt there. So there is a question mark. Another form is claim form B form, only one form, okay, for the creditors. And another form is proxy form. These are the 4 and 3 7 forms it is used there. One is in the rule and another is in the regulation. I'm just going back. Now, these are we were talking about the first task of the resolution professional to verify the application and report to the adjudicating authority, my lord, to be accepted or not to be accepted. Now, along with the application, these 10 documents and these H documents, means 8 documents, are to be attached. I just requested Santosh Madam, can you please help me in reading it out?
Sure, sir. Sure. Yeah, the list of documents to be appended to the application. The list of documents attached to this application in order to prove the existence of debt and the amount in default. Second, the copy of income tax returns with detailed computation of the income of the guarantor or the firm, as the case may be, for the previous 3 years. Copy of the personal guarantee contract. Copies of the entries in a banker's book in accordance with the Banker's Book Evidence Act 1891. The latest and complete copy of the financial contract reflecting all amendments and waivers to date. Copies of relevant ownership and title documents for all assets. Copy of the authorization wherever required under this form. Proof that the application fee has been paid. Documentary evidence of all the information sought in each entry for each part of the form. A statement of affairs of the guarantor made up to date, not earlier than 7 days from the date of the application, including the following information and supporting documents, namely.
Yeah, thank you. We will read those things next after explaining and after we go through this. Thank you, madam. And you know, now the first item is coming that the list of documents attached to the application in order to prove the existence of the debt. There will not be any issue. Bank is having that. Now the question, copy of income tax return with detailed computation of income, guarantor, firm, or in the case maybe in the previous 3 years. I don't know whether the banks are having this. Santosh madam, when in your case you got this income tax return and all this stuff of the guarantor?
No, sir, not for the last 3 years.
Also, and there is no stipulation is coming that they have to get the copy, right?
Yeah, in fact, we didn't submit.
In fact, if that income tax return copy is available, Santosh Madam, you know, in the bankruptcy part, the trustee will have an advantages. What is that advantages? Because in the income tax return, the asset owned by the assessee is mentioned there. Especially the immovable property and assets owned in abroad and all those things, which will give a fair idea to the trustee to understand that where is the zero. I just wanted to convey something more. When in India land are registered, this is to be registered in connection in connection with the PAN. It means this information are going to the income tax authority. Earlier, when we are talking that if RP is feel that he required more information or trustee, when the case of come trustee, then he has the right to go to ask the detail from the debtors, creditors, or any other person. It means we can approach income tax authority to give the details of the land registration, whatever it is happened by this PAN number or an SRO. But that is coming in detail when we are discussing of the bankruptcy part. I just commented only. Now the very important data, that is copy of the personal guarantor contract. This is the fundamental agreement.
Yeah.
Suppose, madam, you got it?
Yes, sir. Yes, sir. This was very much available.
Yes, yes. So
even all the revisions.
That everybody is, every bank and financial institution to follow, which is an agreement as per the Indian Contract Act. But in this 10 list, one important list is not there. That is, madam, can you identify what is that item?
The relevant ownership and the title documents.
Yeah, it means the net worth certificate. Net worth certificate will have all the assets and all these things, gold, jewelry, billion and all those things. Correct, na?
Yeah.
It is not coming up here, but you know, when bank are executing these are the two documents they used to have it with them. Number one, about the personal guarantor contract and the net worth certificate. Net worth certificate may be attested by a chartered accountant or may not be. Correct. But mostly the net worth certificate may not be available. If at all available, it will be blank. Correct. Now, the other thing I'm talking about copies of the entries in the bank account very well, that will be available. The least, the complete copy of the financial contract reflecting all amendment and waivers to date. See, these we are expected to get together with the obligation, and these are not really getting it, and there is no coming up. Okay, so these are listed here, but it is not coming it up. Copies of relevant ownership and title of documents of the assets. You know, when this guarantor execute the guarantee contract, there may not be nothing. There may not be no reference about any asset. So these are there, but still we have to see. And when we are giving report, we have to quote all these 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. When we are reporting, I have verified the application. One, I have found, yes, these items are coming from the, application rule. Okay, so we have to quote also that as per the application rule, this thing, that thing is 1 to 10. I verified list of documents, yes, available. Copies of the income tax not available. Requesting to the bank to give the provide the data. And if that's the case, bank is supposed to give it within 7 days. And copy of the personal guarantor contract, it will be readily available. Copy of the all these things, number one, you have to certify. If you don't have, you have to ask to get this copy from the bank or the financial institution. Right, the eighth one is coming, the seventh one is coming out, the copy of authorization, whether required under this form, right? And eighth one, proof that the application fees is being paid. That is 2,000 rupees, if I'm right. That's not a problem. Unless it is paid, adjudicating authority will not take this case. Documentary evidence in all information sought in each entry of each part of the form. See, this 1 to 10 is forms to be attached. See, this is to be attached with the Form A. Form A, I have not taken it here. There is a detailed line items are coming up. Okay, these are forming part of as an attachment to the Form A. Now it is coming. We have to get a statement of affairs of the guarantor made up to the date not earlier than 7 days from the date of the application, including the following information and support documents, namely. Santosh Madam, can you please help me?
Yeah, sure. Sir. Guarantor's assets, inclusive of assets which may be excluded assets and liabilities for the previous 3 years. Secured and unsecured debts, inclusive of excluded debts mentioned above, with names of creditors and all requisite details for the previous 3 years. Particulars of the debt owned by the guarantors to associates of the CD for the previous 3 years. Guarantees given in relation to any of the debts of the CD, and if any of the guarantors is an associate of CD. Financial statements with all the annexures and schedules for the business owned by the guarantor or of the firm in which the guarantor is a partner for the previous 3 years. Wealth tax statements filed by the guarantor for the previous 5 years. Income statement of the guarantor for the previous 3 years. Payment of indirect taxes, including GST, for the previous 3 years.
My only interesting thing, wealth tax statement. Wealth tax is abolished a year back. Now this regulation is, the application rule is coming up in 2019. I don't know where from bank can give this wealth tax expense. That's number one. Madam, Roshan is there? Roshan? Or Rajana Madam is there?
Yes, I am there.
Yeah, Madam, it's good, Rajana Madam. See, while you are verifying, have you got all this information from the financial creditor?
Yes, I got all these.
Great. All this information you got it.
Yes, yes.
Okay, so they are keeping all the guarantor's assets and liabilities in the previous 3 years, secured and unsecured debt, excluding the excluded debt, and particulars of debt owned by the guarantor, and guarantee given in relation to any other debt, financial statement in the annexes and schedule and etc. of the firm or the person guarantor, wealth tax statement. You got the wealth tax statement also, madam?
I didn't got the wealth tax statement.
Income statement of the guarantor?
Yeah, income statement I got.
Payment of taxes and indirect taxes and all those things, you got it?
No, because the guarantor was an injured.
Anyway, now these are the things in subsidiary to come as a statement of affairs of the guarantor. Now all these things 1 to 10, which is forming part of Form A, and regarding the affairs of the guarantor, A to H are the set of documents which is to be forming part of Form A, that is the application to the adjudicating authority. Now, these are the set of documents which we have to verify and submit a report. Immediately after 10 days, within 10 days of our appointment. I think it is clear to the viewers and members what we are talking about this, right? I am just moving to the next, this we discussed already. Now we are coming to the crux area. Acha, we are talking about here excluded debt and the related party that we are coming later. Now, important definition. Section 522, personal guarantor is defined as means an individual who is surety in a contract of guarantee. So it's a contract of guarantee to a corporate debtor. Okay, it's a contract of guarantee. Now we are coming to the regulations. Regulation means application to adjudicating. It's a rule actually. Application to adjudicating authority for the insolvency resolution process of the guarantor corporate rules. We seen that, we are not seen it, we discussed this regulation 6 application by guarantor, which is leading to the section 94, and regulation 7 talk about application by the creditor, which is the basis for section 95. In the case of Regulation 6, when a guarantor is approaching adjudicating authority, invoking section 94, he has to use Form A, which we have already seen. In the Form A, you have seen that what are the things to be attached. Okay. Rajana madam maybe got an application filed by the guarantor or filed by the FC madam.
It was filed by the FC, section 7.
FC, fine. Then the guarantor shall serve forthwith a copy of the application referred in Rule 1, every financial creditors and the corporate debtor for which for whom the guarantor was taken. So when he is filing invoking section 94, he has to give the petition copy to the FC, all FC, and the CD for which he stands as a guarantor. So that is what application regulations, application rule. I am sorry to return there the regulation, it's a rule. Okay, it's talking about. That's what invocation of 94. Regulation 7, it's not regulation, rule 7 of application by the creditor. A demand notice is saved as we seen and discussed as per section 9 case. A demand is to be formed, is to be sent, and we have to wait for 14 days and all those things. Then only we can invoke section 95. The application under section 1 of section 95 shall be submitted in Form C along with the fees of 2,000 rupees. Yes. So we have to give the demand notice in B, and C we have to file the application to the adjudicating authority after submitting 2,000 rupees, and Form A is to be filed by the personal guarantor himself when he is invoking section 94. The creditor shall serve forthwith a copy of the application referred. So as usual, we have seen that a copy is to be given to the creditor, I mean the personal guarantor. Also, we have to give a copy to the corporate debtor. In case of joint application, this is related to the partnership. I don't think that we need to touch upon. Okay. Again, I just read it that in case of joint application, the creditor may nominate on one among themselves to act behalf of all the creditors. Maybe applicable for PG also. Now, Rule 9, copy of application, and Rule 10, filing of application and the documents. Rule 10, copy of application. What does it mean? The applicant shall file, the applicant shall provide a copy to the application filed under section 1 of section 94 in the case of creditors, and subsection 1 of section 95 in the case of financial creditors, as the case may be, if not provided earlier. So that copy is to be given unless it is paid earlier to the resolution professional within 3 days of his appointment. Correct? And of his appointment when section 95 is applied. But you remember, a copy of the application is to be given to the creditor and corporate debtor as well as CD and the corporate guarantor at the time of filing itself. Here, in the case of resolution professional, it is to be paid, it is to be provided to the RP within 3 days of his appointment under section 97. Now, filing of application and documents. See, this we need not to go with that, which is talking about when the rules and regulation is not coming up, what is to be followed up with that. So this is just a directive portion, which I am not going to take it up. Regulation 10 of filing application and documents. This is also a procedural aspect which is not having a relevancy now. Okay, so before coming this rules and regulation, what is the matter to be followed? That is what it is talking about. Not much relevant. Now, withdrawal application, we have seen that Rule 11 is talking about withdrawal application. There is no section for that. Rule is talking about that. The adjudicating authority may permit withdrawal of the application submitted under regulation 6 or 7, as the case may be. 6 by the guarantor himself, 7 by the FC. Before its admission, on request of the applicant. So if it is not admitted, then the applicant himself can apply to the adjudicating, my lord, please withdraw. If it is admitted, but after the admission, on the request made by the applicant, in 90% of the creditors agree to such withdrawal. So here is the condition. If once it is approved, then 90% of the creditors agree for such withdrawal. So rule 11 2, application for withdrawal under the clause B in the case of withdrawal after admission of such a rule, one shall be in the form D, which we have seen that in the rule, the last form D is to be filed, right? Now from here, our sections are starting. So sections 94 and 95. Section 94, application by the debtor initiating insolvency resolution process. Section 95, by the creditor. A debtor who commits a default. What is the defaulted amount? It is 1,000, okay, which is talking in the section 79, may apply either personally or through a resolution professional to the adjudicating authority for initiation of the insolvency process by submitting an application. Here we are talking about a debtor who commit default may apply to the adjudicating authority initiating resolution process by submitting an application. Commit a default. What is default? The default should not be on the excluded debt. We will see this excluded debt, what it is talking about. There are certain debt which are categorically excluded as excluded debt. On such debt, there is no invocation is possible under section 95 or section 95. So there is two debt, excluded and included debt. Okay. The debtor shall not be entitled to make application under subsection 1 if he is. Now this is the restrictive clauses is there. There are 4 clauses are there. A personal guarantor himself, he cannot invoke section 94 if an undischarged bankrupt, he is already bankrupt and not undischarged bankrupt, he cannot go again. Means if FC is filed the invocation and if the resolution plan is not implemented, repayment plan is not implemented, he become an undischarged bankrupt. Again, he cannot go on to invoke section 94. Second category, undergoing fresh start process. Fresh start process is very minute debt cases. Okay. And undergoing insolvency resolution process. I mean that process is going on under section 94 and so on. It is already going on. Undergoing bankruptcy. It means a personal resolution is going on. He cannot go and invoke again 94. Yeah, bankruptcy is going on. Then he cannot go come back and invoke these things. Just technical matter. A debtor shall not be eligible to apply under section 1 if an application under the chapter has been admitted. Remember, this debtor shall not eligible to apply under section 1 of section 94 if an application under this chapter has been admitted. This chapter has been admitted means section 95. Okay. When section 95, he cannot go and again invoke the section 94. Application shall be submitted, shall be in such form. We see that form and such manner, accompanied by such fees and such documents. We have seen what are the documents is to be attached with the forms. This is what simple invocation of 94 and section 95. When section 95 application by the creditor to initiate the insolvency resolution process, a creditor, I just highlighted the word creditor, I don't know why, but let me see, may apply either by himself or jointly with the other creditors. In the case of personal guarantor, there is no joint application. It is not joint application. Here, jointly with the other creditors, or that's the reason I may be highlighted creditor, or through a resolution professional to the adjudicating authority for initiating insolvency resolution process under this section by submitting an application with the relevant documents attached. An application under subsection 1 shall be accompanied with the details and documents relating to. Already we have seen some document. Apart from that, within the section, it is stated that the debt owed by the debtor to the creditor and or the creditor submitting the application of insolvency resolution process as of the date of application. B, the failure by the debtor to pay the proper debtor within a period of 14 days of serving notice. Here it is important that 14 days form we have to file it, then we have to wait for 14 days, then we have to file and invoke section 95. Relevant evidence of such defaults upon non-payment of the debtor, creditor shall also provide a copy of the application made under this to the debtor, and the application referred to section 1 shall be in such form and the manner accompanied by such fees, 2000 maybe. The detail of the documents required to be submitted under subsection 4 shall be such as may be specified. We have seen the specification, what are the things to be attached together with the application, right? Now, what is excluded debt, which we are talking about in a debt? That there is default of debt. What is excluded debt? See, there are 4 categories are there. Liability to pay fine imposed on a court or tribunal. Any penalty or such fine, etc., imposed by a court. It is an excluded debt on which we cannot invoke 94 or 95. Liability to pay the damages to the negligence, nuisance, breach of statutory, contractual, or other legal obligation. We cannot go. It means what? We cannot go for a resolution for all these liabilities. And liability to pay maintenance to any person under any law for the timing in force. So we cannot go to the adjudicating authority if a debt is there, which is imposed by the court or penalty or something like that, for the total negligence and nuisance and a maintenance cost. And liability in relation to the student loan, we cannot invoke. Any other debt as may be prescribed. As of now, these are the things. There is no other debt. So these are the excluded debt. There is no question that any default made in this, we cannot invoke those section 94 and 95. Now, while we discussing of the chapter break, we were talking about moratorium and the old one, interim moratorium. I already said section 96. When an application is filed under section 94 and 95, an interim moratorium shall be commenced on the date of application, on the submission to the adjudicating authority in relation to all the debt. And here the word is used, the all debts shall cease to have the effect on the date of submission, of such application. Means the interim moratorium is applicable on the date of application, but cease to be exit on at the time of admission under section 100. So it is a small relaxation given to the personal guarantor that he will not be disturbed. Here the question is on the all debt. It is not separately mentioned that excluded debt. It's not mentioned. It's understood that yes, all debt. And during this interim moratorium period, as usual, nothing can be invoked on these things. But be careful, any legal action on proceedings pending in respect of any debt. Here it is not telling that we cannot do or litigation and all those things, but litigation on any debt. The word is usually any debt. It is inclusive of excluded debt. Shall be deemed to have been stayed. But here there is no litigation, other litigation, etc. It can be happen. But as far as question related to any debt, it is stated. And the creditors of the debtor shall not initiate any legal action or proceeding in respect of the debtor. So it is inclusive. So other matter, yes, obviously it can be done. Now I just request either Setiji or Santosh Madam, can you please help me? Section 97 and 98.
Yes, sir. Section 97, appointment of resolution professionals, RP. 97.1, If the application under section 94 or 95 is filed through a RP, then the AA shall direct the board within 7 days of the date of application to confirm that there are no disciplinary proceedings pending against the RP. 97.2. The board shall within 7 days of the receipt of the directions under section or subsection 1 communicate to the adjudicating authority in writing either confirming the appointment of RP or rejecting the appointment of RP and nominating another RP for the insolvency resolution process. 97.3. There were 97.1 and 2 very clear. I think need not require any explanation as such. 97.3. Where an application under section 94 or 95 is filed by the debtor or the creditor himself, as the case may be, and not through the RP, the adjudicating authority shall direct the board within 7 days of the filing of such application to nominate an RP for the insolvency resolution process. Section 97.4. The board shall nominate a RP within 10 days of the receiving of the direction issued by the adjudicating authority as above. Then the adjudicating authority shall by order appoint the RP recommended under the above section. The RP appointed by the adjudicating authority as in subsection 5 shall be provided a copy of the application for the insolvency resolution process.
Thank you. See, there is nothing to worry. There are two things. If the RP name is RP name, the application is filed, he will put in the RP. If there is no reference about RP, NCLT will select the guy from the empanelment list. These other things are just written there, but it is not followed up. It will be taken. And the only thing, when the RP is selected from the list, it will say that NCLT will say that you please give a submission that you are not disqualified. That's it. Once he filed it, everything is over. These are not followed up. Simply, they will appoint you from the empanelment list, and for this is an administrative part, sending message to adjudicating IBBI, then IBBI has to find out a guy, then communicate. Instead of avoiding that, NCLT, as you know, for every 6 months they are given the list. You can appoint any. Anuj is filed a case against all those things which all of you are aware about it. You can appoint any or n number. That is there. Anyway, that is on the other side. And section 98, we can also replace resolution professional. No need to read this thing. I just simply tell it is replace can be happen either by the request of the creditor or the debtor. Okay, and it is written so many things that 10 days, 7 days, and all that. This is not hard to happen. When RP name is suggested, it will be taken. Otherwise, what will happen? It will be taken from the empanelment list. Nothing much more than this big language, and nothing to see more on this. Section 99, submission of report by resolution professional. You know why when we are going to report to the resolution professional about the plan. Submission of report by the resolution plan. The resolution professional shall examine the application referred in section 94, 95. So in the 94 and 94, whatever the document is attached, I mean 1 to 10 and A to H, what is listed, correct? So that we have to verify and give report to adjudicating authority. When we prepare the report, we strictly follow what is there written in the rule. Rule number 1, 2, 3, 4, 5, 6, 7, 8, 9. We have to give the answer. If it is not given, we maybe get questioned. What, why, what about this, what about this, what about this? For avoiding that, you follow that number and A to H. Whatever is provided to you, you have to answer to that. See, these informations are to be provided by the applicant. It is not your duty to find out that to go and get this data from somewhere and somewhere. Correct enough? Because it is already forming part of the application. What we need to do here, we have to verify the application and submit a report to the my lord that yes, admit. These are the defects, don't admit. So that is the simple process we are talking about here. Correct. And we talk about few timeline that also we have discussed it. Like in 1995, the person from whom information explanation sought under section 4 shall furnish such information or explanation within 7 days of the receipt of request, which we are discussed now. For the purpose of examining this application, the resolution professional may seek such further information explanation in connection with the application as may be required by the debtor or from the creditor or any other person who is in the opinion of the resolution professional may provide such information. If everything it is attached with the application, what Rajana Madam is talking about, well and good, you verify and give the report. If certain few things are not there, you ask to the person, creditor and debtor, but you know within these 7 days nothing is going to happen, and they are not going to give it at all. But whatever the position, you have to write a report on that. Yes, I was requested the person to give the reply. This is the registered letter and this is the mail and all those things. I have not received within 7 days any information tenor on that. Here it is not talking about that you have to enforce and get these things, right? There is no enforcement. There is no kabja and all those things is there. It's not mentioned there, correct? There in the CARB it is taking that IRP has to take custody of all the assets and the books of document and other thing and etc of the CD. It is just like PPIRP. We are not taking here. Here it is very important to say that unlike CARP, here we are not taking the possession. Nowhere it is taken that we have to take the possession of the PG. But going forward, certain things are coming up. Then the question is coming up: can RP, in the case of personal resolution of personal guarantor, is eligible to or authorized to take possession? Few things are coming up, which is creating some confusions, which we will discuss. Now, that is what all about this. Now, we have to give a report to the adjudicating authority that I have verified the application and its annexes 1 to 10, A to H, that these are the things are the finding according to me after verification of the report and due diligence scrutiny of thing found that accept the case or reject the case. Now, section 100. This is the admission section or rejection section. Based on all these, whatever we are reporting, adjudicating authority will decide whether to accept or to reject. My dear, if the application is rejected, it is just like what we are seeing in the CARP of rejection of CARP cases. It will lead to liquidation. Here it lead to bankruptcy by filing an application. Here, in both the case, guarantor or the creditor has to file application. Then only that bankruptcy is applicable coming up. Okay, so that is what the admission part is talking about. But here it is few procedural things is talking about that once it is admitted, certain things are going to happen. That is what moratorium. It is not interim moratorium, but it is a final moratorium. When an application is admitted under section 10, the moratorium shall commence in relation to the, see the word, all the debt and shall cease to have effect at the end of 180 days, beginning with the date of admission of the application or on the date of adjudicating authority pass an order of repayment plan. See, repayment plan or 180 days. These are the end two questions here coming up. Okay. So whichever is earlier, if 180 days is earlier, end. If repayment plan is completed, pass an order, repayment plan completed, moratorium is what. But here it is also written that in relation to all the debts, it is not stated that excluded debt. I am not able to understand why we are writing like this. Why excluded debt? Because all debt mean in other sense 94 or 95 can be invoked on all debt excluding excluded debt. Obviously, the 94 and 95 invoked all the inclusive debt. Maybe all the debt again we can say, we can interpret that it is excluded debt. I'm not sure about it. Now, during the moratorium period, I will see that any legal action proceedings in respect of any debt shall be deemed to have been stayed fine. The creditor cannot initiate anything on the debt. Any debt. Here also the word is used, any debt. Okay. The debtor shall not transfer, alienate, encumber, dispose of any asset of his legal right or the beneficial interest therein. See, all these things are having bigger impact when we are coming to the bankruptcy stage, and there our position is the trustee, that we will see in the next week coming up, and where an order admitting the obligation under section 96 has been made in relation to the firm, and excluding this, it is on the firm part which is not notified. Now the another thing, in continuation to the admission order, moratorium, and public announcement. It is as usual as we have seen in the CARP. Yes, there it is 3 days, here it is 7 days. Within 7 days, we have to advertise. Okay, the public notice is to given, and 21 days is to be given for collecting the claim and all these things. Correct? It should be the notice of subsection 1, including detail of order of admission, that is there, and particulars of the resolution professional. Yes, obviously we have seen that, and the last date of submission of the claim is there, and notice shall be published at least English and vernacular. But the beauty is that it is very clearly stated that in the state in which the debtor resides. Very clear. If it is in Maharashtra, the entire Maharashtra. If it is in Chennai, then entire Tamil Nadu. If it is in UP, then entire UP, and so on. It is having very clarity, but CRP there is no clarity where it is. Clarity is there, but the area again is a constraint. Okay, it is not talking about the state. It is not talking about the. It's talking about the particular area.
So, sir, here, if there is one query, like if the debtor resides in Kolkata and he has a place of business in Delhi, so it would be in Kolkata.
Where the debtor resides. Where the debtor resides. Place of business is not in the question. The state where the debtor resides.
But all his business operations are in Delhi.
Why should you worry about business operation? What is written to us? In the state where the debtor resides. I know this question, that's why I highlighted with red.
Right.
Correct, circulated in the state where debtor resides. It's very clear. It's not talking about permanent places, whether he's NRI, non-NRI, all of these is not coming up. Right? Very clear on that. Now, affix in the premises of adjudicating authority, which we are never experienced in CRP, and place on the website of the adjudicating authority. So these are the things coming up, public notice. Now, after this, 103, section 103, registration of the claim. As we have seen in the CARP, the creditor shall register the claim with the resolution professional sending detailed claim by way of electronically communications through the courier, speed post, whatever it is. And in addition to the claim referred in subsection 1, creditors shall provide to the resolution process personal information and such particulars as may be prescribed. I have not seen any prescription either in the regulation or rule. Okay, it is to be prescribed. That's what my best knowledge. And section 104, preparation of the list of creditors. Yes, as we seen in the CRP, the resolution professional shall prepare the list of creditors on the basis of AB. The information disclosed in the application by the debtor and under section 94-95, as the case may be, claim received by the resolution professional under section 102. Now the problem, the information disclosed in the application by the debtor. When he files section 94 and 95, he has to give, these are the default. That is one base. or the claim received by the resolution professional. Now, it is personal matter. How do we now go and see and settle the list and all those things, verification and all those things that we are going to see now how it is going to happen. The resolution professional shall prepare a list. We can prepare a list whatever we received within 30 days from the date of notice. The original notice we are given within 7 days from the date of from their 30 days. Means 21 days we are having 0 plus 7, 7 plus 21, that is again 28. Then we are talking about 30 days of the notice. It means 21 plus 7, that is 21 plus 30 days. Repayment plan. Now repayment plan, it is come up. Now it is coming up, report by the resolution process repayment plan, summoning and meeting of the creditors, and the conclusion of the meeting, voting right. Now you tell me was, now the question is coming that, how do we conclude the list of creditors? Correct. We got the claim, and we got the claim from the creditors. On the other hand, we have the detail in the application that these are by default. Correct. Now the question is coming up, how do we prepare the list of creditors? That we have seen that, yes, we have to prepare A, and done for A and B. A as it is given by the debtor, C as it is given by the creditor. I don't know, but when in actual scenario come up, if there are several creditors, it is a matter how to verify for that. But verification matter is also silent over the section rules and regulations, as we seen in the CARP. So since it is a personal thing, obviously debtor will disclose my lord or my dear RP, these are my liabilities. Okay. If he is disclosing, we will be getting a claim that we have to get it reconciled with the CD. Now repayment plan. What is the repayment plan is coming up. Here it is repayment plan resolution, which is in other sense it is called the repayment plan. The debtor shall prepare in consultation with the resolution professional. Who is the preparer? The debtor is getting prepared, not by the resolution professional, but in consultation with the resolution professional. I don't know what consultation he will do with the preparation of this resolution. I mean the repayment plan. Anyway, it is written there. He has to prepare in consultation with you repayment plan containing the proposal to the creditor restructuring his debt. Yes. Repayment plan may authorize or require resolution professional to do. Three things resolution professional has to do on this. Carry on the debt. This is what I'm talking about now. Whether it is takeover of the CD, like we seen in the CERP, whether it is a takeover of the, taking possession of the PG. Now you see, carrying on the debtor's business or trade on his behalf or in his name. Be careful, boss. The payment plan may authorize requiring the resolution professional to, when he is listening the debtor on the repayment plan, it should be clear that who is going to do the business of his business, how it is going to do that one. I mean, the RP or he himself. It's a gray area, there is no guidelines given. Now realize the assets of the debtor. Realize the assets of the debtor. We have seen one asset is called the excluded assets. Now it is coming to the realizable asset. Again, we will have to see some more thing. Administer the dispose the fund of the debt. See, he may be having some fund on that we have to administer. It's not clearly stated that in this process, are we going to take custody of the assets of the debtor? he will be coming with a resolution plan. I may sell this, I may sell that, I may liquidate this deposits. The total sum is this, out of this, this is going to pay it and all. I am running a business. From there, I am getting monthly revenue this much. That you can utilize for the payment of the debt. Now the question, who run the business? Whether it is RP or himself. We can conclude it as he himself is doing, because carrying on the debtor's business or trade on him behalf of his name, or it is to be stated in the repayment plan. Right? We have to be very careful here. We are going to take somebody's business, and if we are not having the acumen and all those things, take and run that business, etc. We have to be very careful in preparation of this repayment plan. We have to be very careful, those who are having business, etc. Now, subsection 3, repayment plan shall include the following, namely, justification of preparation of such a repayment plan and reason on the basis which the creditors may agree upon that. My dear friends, this repayment plan is not prepared in consultation with the creditor, but debtor in consultation with the RP. But RP has to give a justification report, such repayment plan, and reason on the basis which creditor may agree upon the plan. Yes, I am okay, justified, okay, after seeing all those things, and these are the reasons which I feel that creditor may accept it. Now here, provision for payment of fees to resolution professional, that we never forgot. Such other matter, there is no such other matter. Now, repayment of resolution professional or repayment plan. Now, submission of summoning of meeting of the creditor. These are the two things. So we prepared the repayment plan. The debtor prepared the repayment plan in consultation with me. Then the resolution professional has to vet it, and he should prepare what is the justification and why he feels that the creditor will accept it. Right? Then the problem, he has to submit adjudicating authority pleading that, my lord, it required a consultation of the creditors. It may not record a consultation of the creditors. If it is required the consultation of the creditor, then the summoning of the meeting of the creditors. If not required, if RP is reporting that there is no requirement of summoning the creditor because of this reason, then adjudicating authority will approve the resolution plan. If it is required the consent of the creditor, then we have to call adjudicating authority will fix up for the summoning of the creditors. Now, I'm not talking about the report of the resolution professional repayment plan, which we already discussed there. And see, it is purely a few things it is there. Considering the time limit and all those things, I'm not, the simple language is written there. It is very easy to understand that regarding the report of the resolution professional repayment plan. Report is to be submitted to the adjudicating authority. Right. Now, in the report, RP has to say that, my lord, it is required to have the creditors meeting, or my lord, it is not required to have the creditors meeting. Yes, if it is required to have the creditors meeting, then summon. So what is the time limit for summoning the creditors? The 14 days before the day fixed for such a meeting, resolution professional shall issue a notice calling the meeting of the creditors. The resolution professional shall send a notice of the meeting to all the listed creditors, which is prepared under section 104. The notice sent under the section 1 shall state the address of the adjudicating authority to which the repayment plan is submitted. Correct? And the resolution professional of repayment plan has been submitted and shall be accompanied by 4 items. The copy of the repayment plan, a copy of the statement of affairs of the debtor, which we have seen along with the application of the statement of affairs of the city, not CD, the debtor, the copy of the said report of the resolution professional, which we are seeing in 106, form for the proxy, which we have seen in the regulation, that is form D. Now, this notice, this resolution plan and the plan is to be circulated to the creditor, for which a notice to be issued. So 107.3 is telling that the notice sent under sub-regulation 1 shall state the address of the adjudicating authority to where the repayment plan and report is submitted by the resolution professional. Correct? And the repayment has been submitted and shall accompanied by these 4 documents. Perfect. Now the proxy voting, we said that is there. Proxy is available. Proxy can attend. Proxy can also go for proxy e-voting. Now 108, conduct of the meeting of the creditors. So how the once adjudicating authority said, okay, you go and conduct the meeting of the creditors. The meeting of the creditor shall be conducted in accordance with the provisions of this section 109, 1110, 1111. That's what we are now going to see, that how the creditors meeting is get conducted. In the meeting of the creditor may decide to approve, modify, or reject. Reject, then it will end up with the bankruptcy. Approve, well and good. Modification, yes, possible. The resolution professional shall ensure that if modifications are suggested by the creditor, the consent of the debtor shall be obtained for each such modification. That's it. You accept, modify, take the consent of the debtor, or reject. These are the things there. The resolution professional may, for sufficient cause, adjourn the meeting for a period, but not less than 7 days. Okay? Not more than 7 days. Okay. The meeting of the creditor, we can adjourn, but within 7 days, he has to call up the meeting. 109, voting right in the meeting of the creditor. This is what we have seen in the CER, nothing about it. Okay. Only based on the value and all those things, it is decided. Correct. A creditor shall be entitled to vote. Yes. Every meeting. Yes. A creditor in respect of the repayment plan in accordance with the voting share assigned to him. Now, what is the voting share to be assigned? That we will see. Resolution professional shall determine the voting share to be assigned to each creditor in the manner specified by the board. Yes, there is in the regulation, the manner is specified, that is the same what we have seen for the CRP and all. The creditor shall not be entitled to vote in a meeting of the creditor if, very simple, is not a creditor mentioned in the list. What the list name? Creditors, or he is an associated debtor. See, associated debtor here, it is nothing but it is a related party. In other way, we can say these 2 persons is not having the voting right. Section 79, associated person of the debtor, which we are seeing here, no? Associated debtor. Who is that? Santosh Madam, can you take this section 79 to? It is 79 to, yeah, section 79 to.
Yes, sir.
Or
Yeah,
Ramjit,
section.
Yeah, please, somebody.
Paramjit sir, Teddy sir, are you there?
Yes, madam. Yeah.
Yeah, please take up this section 79.
79 to associates of debtors means a person who belongs to immediate family of the debtor, or a person who is relative of the debtor, or a relative of the spouse of the debtor, or a person who is in partnership with the debtor, or a person who is a spouse or relative of any person with whom the debtor is in partnership, or a person who is employer of the debtor or employee of the debtor, or a person who is trustee of a trust in which the beneficiary of the trust included debtor, or the term of trust confer a power on the trustee which may be exercised for the benefit of the debtor, and a company where the debtor or the debtor along with his associates own more than 50% of the share capital of the company or control the appointment of board of director of the company. An explanation for the purpose of this subsection, relative with reference to any person means anyone who is related to another if they are member of HUF or one person is related to other in such manner as may be prescribed.
Thank you, Satiji. I don't think I need to explain this. We all are professionally able to understand very simply. I don't want to take time and waste you and get bored. We are moving to the next. Right of secured creditor in relation to repayment plan. You know, the creditors include secured creditor and unsecured creditor. Now, a secured creditor shall be entitled. A secured creditor shall be entitled to participate and vote in the meeting of the creditor. Yes, a secured creditor participating in the meeting of the creditors and voting in relation to the repayment of plan shall forfeit his right to enforce the security during the period of repayment plan in accordance with the term of repayment plan. My dear friend, he has the voting right only if he forfeit his security interest during the period of a repayment plan. It is very specific. During the repayment plan, I will forfeit. You have the right to vote on that. Whereas secured creditor does not forfeit his right to enforce the security interest. He shall submit an affidavit to the resolution professional at the meeting of the creditor stating that the right to vote exercised by the secured creditor is only in respect of unsecured part of the debt. For the secured part, he is not relinquished, right? As long as he is not relinquished, he can participate only to the unsecured portion of the debt, provided he has to give an affidavit. The estimated value of unsecured part of the debt that is to be given. I think it is very clear. If I forfeit, I have the right. If I don't forfeit, then I have the right only on the unsecured portion of the repayment plan. In case secured creditor participates in voting on repayment by submitting an affidavit under section 3, what we said, the secured and unsecured part of the debt shall be treated as separate debt. It means the creditor, the secured creditor, participates in voting repayment plan by submitting an affidavit. What affidavit he has to submit? That the secured creditor does not forfeit the right enforceable the security. I am not going to forfeit my enforceability on the security interest, which is submitted through an affidavit. Then the secured portion and unsecured portion are voted separately. In case of a secured creditor participates in voting of repayment plan by submitting an affidavit as stated 3, the secured and unsecured part of the debt shall be treated as separate debt. I think you are understanding that. If I'm relinquishing, I have a right. If I'm not relinquishing, then I don't have the right. I have the right only on the unsecured portion. Correct. Now, right. Now, the concurrence of the secured creditor shall be obtained if he does not participate in the voting on repayment plan by provision of the repayment plan affecting his right of enforceability security. Means if he's not relinquishing, then the thing, a consent is to be obtained from the financial creditor. It's telling that the concurrence of the secured creditor shall be obtained by whom? The RP, if he does not participate in the voting of repayment plan by provision of the repayment plan affecting his right to the enforced security interest. Okay? Explanation is given. It is very clear that for the purpose of this section, period of repayment plan means the period from the date of the order passed under 114 till the date which the notice is given by the resolution professional under section 117, the report submitted by the resolution professional under section 119, as the case may be, that everything is completed. Okay, now 111 is talking about the approval of repayment plan by the creditor. The repayment plan or any modification to the repayment plan, if a modification is did, then it is approved by the debtor by the majority of more than 3/4. As we seen in the company's agreement, the same funda is coming here. 3/4 in value, creditors presented in person, by proxy, and voting on resolution in a meeting of creditors, approval of the repayment by creditor. I'm not going to waste time on those things which are very clear to all our professionals who all are aware about this company's act and its role on this ruling. Report of the meeting of the creditors on the repayment plan. Yes, we conducted the meeting of the creditors. Now, whatever we are decided, we have to report to the NCLT. So, under section 111, notice of the decision taken in the meeting of the creditor is also to be considered. Now, 112 talking about report of meeting of the creditors on repayment plan, which telling that the resolution professional shall prepare a report of the meeting of the creditor on repayment plan. The report under subsection 1 shall contain these important 4 things: whether the repayment plan was approved or rejected, and if approved, the list of modification, if any. Rejected by whom? The creditors. Now B, the resolution which were proposed at the meeting and the decision of such resolutions. Fine. List of creditors who were present or presented at the meeting and voting record of each creditor for all meeting of the creditors and such other information as the resolution professional think appropriate to know to the adjudicating authority. So simple as that, a report is submitted. Only thing, whatever the modifications that we have to state, what these are the modifications done, for which the consent of the debtors is also very much required. Now, notice of the decision taken at the meeting of the creditors. The resolution professional shall provide a copy of the report of the meeting of the creditors prepared under section 99. What we have seen earlier when we convened the meeting and all those things. Then a copy is to be given to the debtor. The same is to be given to the creditor, including those who were not presented. Very important. Those who are not present at the meeting and obviously adjudicating authority. Now, section 114, order of adjudicating authority on repayment plan. Section 115, effect and order of adjudicating plan. Effect of order of the adjudicating authority of the repayment plan. Now it is coming the implementation and supervision of the plan, completion of the repayment plan, then repayment plan end up prematurely, then discharge order. By this, our session is going to end up, right? Now, just wait for a few minutes, sir. Now, order of adjudicating authority on the repayment plan. The adjudicating authority shall by an order approve or reject the repayment plan. If it is rejected, then a debtor or the creditor is having an option to go for apply for the bankruptcy. If it is approved, well, execute the repayment plan. Now, provided that where a meeting of the creditor is not summoned, we have already said that RP having a RP has to take a due diligence and report to adjudicating authority. My lord, no meeting is required. This is the reason. My lord, yes. Meeting is required. This is the reason. Now, in this case, that where a meeting of creditor is not summoned, the adjudicating authority shall pass an order on the basis of report prepared by the resolution professional under section 106. And the order of the adjudicating authority approving the repayment plan may also provide a direction to for the implementation of it is not simply approving, it is giving a directions for the implementation plan, where the adjudicating authority is of the opinion that the repayment plan requires modification. It may direct the resolution professional to reconvene the meeting of the creditor for reconsidering the repayment plan. When the modification is happening, obviously it requires the consent of the debtor. Now, what is the effect of order of the adjudicating authority on the repayment plan? Where an adjudicating authority has approved the plan repayment under section 114, such payment shall, there are two things to take care, take effect as if proposed by the debtor in the meeting. My dear, now even though taken the consent, once this order is come up, it is as if agreed by the debtor. Second, B, binding the creditor mentioned in the repayment plan and the debtor. So the problem here, it's a question between debtor and creditor. Like since here you have seen it is binding everywhere, correct? No? President of India. Now it is between them only. Now, where an adjudicating authority rejects repayment of the plan, then debtor and the creditor shall be entitled to file application for bankruptcy under chapter 4. That we have seen that section 33 filing under liquidation. Like that, he has to apply for the bankruptcy. Right? A copy of the order passed by the adjudicating authority under section 2, that is where this one is rejected, shall be provided to the board NCLT, I mean IBBI. See, that's the powers of the board, powers of the IBBI, which is clarified under section 96. They are maintained some register, etc. They will mention those things there. Now, implementation of supervision of the repayment clause. It just we have seen that in implementation plan of the resolution plan. The resolution professional shall appoint under section 97, the original appointment, or under section 98, which means the replacement, shall supervise the implementation and payment plan. Here it is stated that supervise, not conduct. Now, if you ask me what do you mean by supervise, yes, money come, money goes. If conduct means I have to collect in my account and I have to pay to the credit. In my account means the plan account. Here it is supervision only. I'm not clear how that supervision it is there. A question mark, which I will find it out. Okay. So it's a supervision. The resolution professional appointed in 97 or 98 shall supervise the implementation of the repayment plan. In liquidation, you know, here in liquidation we are selling, we have to sell and get the money in the liquidation account, we have to repay all those things. Here, debtor agreed, I will pay like this, okay. Creditor agreed, okay, whatever he pay as per this, I agreed. So we have to ensure that what is committed by the debtor is paid. Yes, what is as per the plan, creditor code. This is what the supervision. Please do not make it is complicated with the resolution plus where what RP do. Correct. In the liquidation, what RP do? Here it is very simple that both the person debtor and creditor agreed, these are the amount, these are the timeline, I which pay, yes, supervise, understand, yes, certify. The resolution professional may apply to the adjudicating authority for direction. What direction? If necessary in relation to any particular matter arising under the repayment plan. Yes, we will apply for the directory, my lord, this is the problem, please direct. Adjudicating authority may issue direction to the resolution professional on the basis of an application under subsection 2 of section 116. Now, completion of the repayment plan. The resolution professional shall, within 14 days of the completion of the repayment plan, forward to a person who are bound by the repayment plan under section 115 and the adjudicating authority the following document. When this completed, we have to send one set of document to the creditors, one set of document to the adjudicating authority. What are the documents? A notice that the repayment plan has been fully implemented. Yes, my lord, a copy of the report of the resolution professional summarizing all receipts and payment made in pursuance to the repayment plan, and the extent of implementation of such plan compared with the original repayment plan as approved by the meeting in the creditors. There may be variances. That's what it is mean. Now, the resolution professional may apply to the adjudicating authority to the extent adjudicating authority to extend the time mentioned in subsection 1 for such further period not exceeding 7 days. Means within 14 days he has to report to the adjudicating authority as well as the creditor, but he can again get a 7 days. Yeah, 7 days time for getting an extension, for which the professional has to apply to the adjudicating authority. If he applying to the adjudicating authority, he may get 3-4 months time. Here is he talking about 7 days. Let us see what is there. Now, what happened if a repayment plan coming to end permanently? Nothing, the plan is not implemented. The repayment plan shall be deemed to have come to an end permanently if it has not been fully implemented in respect of all person bounded by it within the period mentioned in the repayment plan. Permanently failed. Where a repayment plan come to an end permanently under this section, the resolution professional shall submit a report to the adjudicating authority, my lord. The receipts and payment made and pursuant to the repayment plan is this. The reason for the permanent, the premature end of the repayment plan is this. The detail of the creditors whose claim has not been paid fully, that is paid, is this. The adjudicating authority shall pass an order on the basis of the report submitted by subsection 2 of section, it is 118, okay, applicable for bankruptcy order under chapter 14, liquidation. Another way, the adjudicating authority shall forward to the person bounded by the repayment plan under section 115 a copy of the what adjudicating authority shall deliver the order copy to the report or submitted by the resolution professional to the adjudicating authority under section 2 and the order passed by the adjudicating authority under section 3. Under subsection 3, the adjudicating authority shall forward a copy of the order to the IBBI under section 196 for recording it in the register. By this, the part is completed. If the repayment plan is accomplished and completed in full, then the order of discharge. If order of discharge is not an undischarged insolvent, that we will come into the next section, which we will call as part 2 of personal insolvency, which we will schedule in the next week, hopefully. Section 119 discharge order. On the basis of the repayment plan, the resolution professional shall apply to the adjudicating authority for a discharge order in relation to the debt mentioned in the repayment plan. To the adjudicating authority may pass such a discharge order. The repayment plan may provide for yearly discharge. Not necessary that they have to wait for till the period completion or discharge on the completion of the implementation plan. Now, the discharge order shall be forwarded to again IBBI under section 196 to mention the record out there and all these things. The discharge order under subsection 3 shall not discharge any other person from any liability in respect of his debt. We have to do it carefully. The discharge order under subsection 3 shall not discharge any other person from any liability in respect of his debt. Simple. Who is who the person? He only getting discharged. This provision is written in conjunction with the CD. His discharge is not going to discharge the liability of the CD. That's what I am talking about. And his discharge is not going to talk the discharge of other PG. That way and this way. Correct. Now, 120 is a standard of conduct of the resolution professionals. And 120 talk about the standard of conduct of the resolution professionals, and that is governed by section 208. Nothing serious about that. It is talking about our conduct, code of conduct and all those things. And that's it about that. We can have a simple reading and understanding, nothing worried about that. And by this, the session is end of it. Next, we have to have the discussion on the bankruptcy that we will schedule and take it up in the next coming up session that we are planning for the next week of that. By this, I am through with my presentation. I try to do it my best level of my preparation for me to take the insolvency cases, personal insolvency cases, for which I given my consent for form file, and for which I have given court. Right. I don't claim that I did it perfectly. This is my preparation. I did for handling my case, and I did for helping my members. My members were PAP members. Doesn't mean that we help only PAP member. I get a lot of calls from other people also. We used to help others also. It is good to see that my old friends from other platforms are gathered here. Very nice to see Sanjay Silkara and Sanjay Katane and all these guys. I cannot read everybody's time. Time is also contributed that, but hereby I'm concluding. Thank you everybody for the presentation which is leading to is expressed on this. I don't know whether I justified. I just acknowledging that this is my attempt of my preparation to take the case where I given commitment. Thank you, and back to Santosh madam.
Thank you, sir. Really, it was very helpful, and we all are very much enlightened by your deliberations. There are a few questions in the chat box. Can we take up those?
Why not?
Yeah. One is to share the PPT, and which I suppose we would get this.
Yeah. 1 second, madam. Satish, in YouTube we can also share. We can attach that this PPT. I don't know whether this PPT, what is prepared, how it is prepared, and all those things are okay or not. But still,
yeah, sir, we will check. We will check with our technical team, and if possible, we will attach to that.
I'm sharing you the PPT straight away now, because you are the admin. If you can possible to post it, please post it. Let it be useful for the people. And we can also attach to the YouTube, where it will be helpful for the viewers whenever they wanted to, whenever they are getting a case, and it will be easy for them to download it from there. Yes, madam.
Yes, sir. Then there's a question by Mr. Shamal. What is the time period by which personal insolvency is to be decided? I suppose this is 180 days from the date of admission of notice by the adjudicating authority.
Yes,
correct me if I'm wrong.
180 days.
Yeah, in fact, your PPT, all this has made a very clear understanding.
180 days.
Then is Ms. Josie Katur. If a PG is absorbed by a special condition in the resolution plan, can a decedent creditor proceed under section 95 against the PG?
Come again, madam.
If a PG is absorbed by a special condition in the resolution plan, can a decedent creditor proceed under section 95 against the PG?
Not clear about the question, but I tell you, see, whatever debtor says, that should be acceptable for the creditor. Whatever creditor says, that should be accepted by the debtor. It is total cancellation. It is not that, see, I am putting like this, whether you accept it. If creditor is not accepted, plan is not going to go. Correct. That is the reason why we are talking about in all things. When this is get accepted, any modification is there, then necessarily CD has to accept it. Correct.
And I suppose any case cannot be made against the PG unless expiry of 1 year.
There is no provision like that. It is mentioned. I have not seen anywhere in that. Case is under what section? Under IBC?
Under section 95.
See, if it is section 94 is admitted, 95 cannot invoke. If it is admitted in 95, 94 cannot be invoked. It is very clearly stated in 94 and 95.
Mr. Joshi, I request if you can make your question clear, or are you satisfied?
Yeah, please.
Mr. Joshi, are you there?
You can unmute yourself and speak.
I think he's not there.
It's not possible when you are admitted under 94. On admission itself, he cannot be taken it again. That's the provision we are talking about.
Yeah. Then is the RP duty bound to submit the reports under section 105 and 112 to IBBI and IPA also?
No. IP is not. Adjudicating authority will forwarding it to IBBI. That's what under section 196. Am I right? 196.
Yeah. Then what fees RP can expect to get work?
1 minute. In the application rule, in the regulation and in the section, nowhere it is stated that we are having some complaints with IBB. I wanted to see that. That's the reason I paid some 4,500-6,000 penalty. Okay. Finally, I don't want to take further problem. If it is delayed, the entire fees may go out. So I paid the penalty. Now I will apply under which section or which regulation which you are charging me the penalty. I'm going to write on that. In nowhere we have seen that these are the things I have to file as an RP to the IBBI. Nowhere. Even public announcement, I have not seen that it is to be filed. Correct. So it is maybe somewhere, I don't know, I have to check on that in a regulation notification circular it is coming up. I could not got that much of time to review it. Anyway, we are learning. We may get a call from somebody.
Sir, 1 minute, sir. Am I audible?
Yes.
Sir, with regard to this payment, I have one small query. See, minimum, the pecuniary limit for filing this application is 1,000 rupees. Yes. Assuming if the default amount is 1 lakh, what would be the fees of RP and what would be the fees of advocate who is filing?
See, the minimum default is 1,000. Now your question is minimum default is 1 lakh.
Yes, default itself is 1 lakh only. So the amount he is not able to pay 1 lakh rupees itself. Then how he will engage RP? How much he can pay?
This is what Rajana Madam is facing. Okay. This is not a standalone case here. This we are seeing in the CARP and all. Correct. Where your fees is 50,000 per month and the creditor is supposed to get only 1 lakh. How do he pay? He's not going to pay you. And if he's not going to pay, adjudicating authority may rise directly him to pay. But if he, even if he is not going to pay, then we have to write again to IBBI, adjudicating authority for the enforceability. Then things will go like that. Then the revenue recovery and all those things. Again.
Then we will become creditor of debtor again.
Yes. Finally, we become insolvent.
Practical issues.
Yes.
Okay. Next, what does RP do if the PG does not cooperate and refuse to prepare repayment plan?
Very simple. There is no
Bankruptcy.
repayment. Very simple. There is no repayment plan.
Ultimately,
debtors
bankruptcy.
have to prepare the repayment plan in consultation with the RP. When he is not cooperating, there is no repayment plan. You go and submit, my lord, there is no repayment plan. Correct. What NCLT will do? Chapa maru, bankruptcy. That is the beauty of this. When this bankruptcy is invoked, then it is going to the liquidation type. Then we have to go on take care of property, talimala, all those things are coming up.
Yes, sir. I think the questions are over. If anyone is willing to ask any other question, it's open. Moreover, the presentation.
Considering the time and all, I think we can band up that you have to decide in Sandesh madam.
Sir, can I ask
Yes,
a question?
I think.
Anybody can ask any question, no problem.
Sir,
I said
sir,
we are in the learning process. Whatever the people know, we will say. Excuse me.
I have two questions. One is that, is there any format for public announcement?
I have not seen any format for the public announcement in regulation in section, but these are the things to be included that is stated in section 102.
Okay, and it says it says adjudicating authority has to give a public notice. Now,
see, my dear, yes, my dear, public adjudicating authority, what will they will do? He has to give a public announcement. He will write in the order is authorized or empowered or RP to do and spend money. If he is not having money, take the money from Muthoot Bank.
okay, the next question, of course, is in respect of fees. Actually, from your experience, that where the application has been made by the creditor under section 95, definitely, because he has made an application under 95, there is a due which he could not recover in CIRP. He filed an application against the personal guarantor. Now, what kinds of fees? Because IBBI has not set any fees for this matter in respect of CIRP, and liquidation fees are set now. But what kinds of?
You mean RP fees?
RP fees, yes. RP fees and expenses. What is the guidance here on that?
There is no guidance. Okay, there is no guidance.
And it will go on for 180 days minimum.
Yeah, that all are there. Okay. Now I tell you what is the market trend. Okay. See, there are FC. There may not be any as such, or they may not be having a net worth certificate. They even not having the asset detail, nothing. Maybe having a piece of agreement. In that, an agreement is there signed. The bankers know they don't have any net worth certificate, nothing. One guarantee agreement is there signed. They wanted to get close the case. They'll file the case, and they know that it is not going to happen. So you know what is the stipulation they say? You agreed for say fees of 50,000. They will stipulate, I will give you upfront 15,000, 15% of this amount. Balance 20% I will give you on submission of the plan. So it is 25, 35. Correct. On admission of the case, I will give you another 25%. On successful implementation, I will give you 50%. Be careful. Finally, we will end up with getting only 15%. 7,500.
Yeah.
Per month. Be very careful. See, I'll give you 15% advance. हम तो खुश हो जाते हैं. वो 20% कब मिलेगा? कुछ प्लान बन गया. 25 कब मिलेगा? तो प्लान एडमिट होगा. वो 50 कब मिलेगा? सब कुछ खत्म होने के बाद. See, these stipulations are released by the bank itself. Some bank is straight away. Okay, fine. Your fees is. We are very careful on these things. I don't know any financial creditor maybe watching, but
are you saying that it should be it cannot be monthly fees? It's for the whole period. The fees for the entire assignment.
They agree for the monthly fees, but they will put condition percentage wise release.
Achha, monthly fees, but percentage wise release.
Yes.
Okay.
Correct, na? Or they may calculate total fees up 50,000 fixed monthly, okay. 3 lakh, 15% I will give you upfront, 20% I will give you on the preparation of the plan, or 20% I will give you on a plan approval, 50% on approval. अरे हुआ क्या? और कोई प्लान भी नहीं आएगा, कुछ वो भी नहीं होगा, कुछ ये भी नहीं होगा, आपको तो मिलेगा 3 लाख रुपए का 15%। आप तो सोच के बैठेगा यार मेरा पर मंथ आएगा 3 लाख रुपए आएगा। But see, these are the things are happening in the market. It's not my view. It's not my version. These are the complaints I am getting my fellow and friends across the country. पैसा इसको क्या करूँगा यार? इसमें तो ऐसे लिखा हुआ है, क्या करूँ? मैं बोलूँगा यार ये इसका जो असलियत क्या है? अरे उनका कोई नेटवर्क नहीं होगा, और लोन देना था बैंक ने तो दे दिया वैसी तैसी, उन्होंने साइन करवा दिया गारंटी पे, ठीक है यार, फिर स्टार्ट था। अब प्रॉब्लम हो गया, कहाँ नेटवर्क सर्टिफिकेट नहीं है, कहाँ इनकम टैक्स सर्टिफिकेट नहीं है, कहाँ वो ये नहीं है, पान कार्ड है सब नहीं है, केवाईसी कुछ है सब नहीं है, उनका कोई प्रोफाइल अता पता वो भी नहीं होगा यार। I'm sorry, because these are the input I'm getting, these are the calls I'm getting, these are the questions and woes and worries I'm getting from the market.
Okay. Okay, thanks.
So while voting, we have to be very careful.
Okay, okay.
Considering the time, I think, yes, we should go ahead. Yeah, so we are very thankful for your enlightening deliberation, and I'm sure all the members must be immensely benefited with this presentation. Now I request Sethi ji to give us a short review of the meeting, today's webinar.
Okay, thank you, madam.
Thank
you. Dear friends, you might have seen that banks are nowadays used to send cases for PGs with educating authorities. So there are a good opportunity for PG cases in the market. And you have also noticed that for allotting any CIRP cases, banks are asking what the experience you have, what infrastructure you have you handled any CIRP cases. So if you are not having any past experience, they are not going to allot you a CIRP cases. So it's like कि पहले अंडा के पहले मुर्गी. So unless you do not have experience, you cannot get CIRP cases. And if you do not get the CIRP case, you do not have the experience. So it is a golden opportunity that we should capture the PG cases. That's why this webinar has been held by the PIPPL. It was the need of the hour, and we should contact the banks. They are sending the PG cases. We should got those cases, and with those we should get some experience, so that in coming time we can get the CIRP cases. And PIPPL is going to organize many such webinars, like how to conduct COC meeting, how to impress the FCs. So we have no vested interest. Our purpose is just to learn, educate the IPs fraternity and help them in case they have any problem. We have also a website. I have given the link of website in the chat box. You can go note that and go to our website. In case you need any help, we have a good team of legal experts. We have advocates on Supreme Courts, and we have experienced consultancy team, domain expert, from whom you can ask in case of any question or help. Our members have handled more than 200 IBC cases, and our GEM panel consultants have handled big chip cases like Jet Airways, JP Infrastructure. We have also YouTube channel. Please join and subscribe to our YouTube channel for knowledge sharing purpose. And this program is also live on that YouTube channel and will be available on YouTube. And with these words, I thank you very much for joining us in a good number. Thank you so much.
Thank you, sir. Now I request Rachna Madam to please give the vote of thanks. Over to you.
Good evening, all. On behalf of Persistent Insolvency Professionals Private Limited, PIPPL, I feel immense pleasure to conclude this webinar with a vote of thanks. I express my sincere gratitude to IP KJ Vinodji for giving us time from his busy schedule to enlighten us on all the important aspects of personal insolvency. Thank you so much, sir, for delving on this topic. For the last 2 hours were very informative and highly interactive. I would also like to thank Mrs. Ramela Ramaswamy and Advocate IP Anup Prakash Avasthi for deliberating this importance on the personal insolvency. My deep sense of thanks and appreciation to all the participants for attending the webinar and making it successful. Last but not the least, I would like to thank the technical support team for efficient conduct of this webinar. So thank you all for being with us today. Thank you.
Thank you, madam.
Rajana madam, I would like to say thanks to you because once you got the case, then only I started reading it.
Thank you.
Rajana, you are the reason for me to get into the personal insurance law much more. You remember?
Sir, you has been a great support to me also regarding the nitty-gritties in the case.
Thank you.
Thank you.
Sir, we can conclude.
Yeah, with these words, we conclude our webinar. And thank you all. And please join us in future also. We will use to send you the link for such knowledge sharing.